कितने लोग हैं? सुपर।
बोलू भाई वो गेट मैं खोल रहा उसको कहना बंद करेगा। दूसरे रूम में सारे एडवोकेट
अभी तो आप लोगों को बोलना पड़ेगा। तो ठीक है। सीमा जी और क्या फिर और क्या करेंगे आगे बढ़ेंगे उसको और उनको जजेस
क्या है मैं
यहाँ से बोलूँगी कैसे कैसे जाएंगे हो जाएगा क्या Honorable dignitaries have arrived amongst us. I feel extremely honored and privileged to welcome the dignitaries to adorn the dais. Honorable Mr. Justice B.R.Ambedkar, Judge Supreme Court of India. Honorable Mr. Justice Sandeep Mehta, Judge Supreme Court of India. Honorable Mr. R. Venkataramani, Attorney General of India. Honorable Justice Maninder Mohan Srivastava, the Chief Justice, Rajasthan High Court. Honorable Mr. Justice Pankaj Bhandari, Judge, Rajasthan High Court, and Honorable Dr. Justice Pushpendra Singh Bhati, Judge, Rajasthan High Court, have arrived amongst us. May I request the dignitaries to please grace the dais. Thank you, Lordship. Good morning, everyone. I am Meghna Jain, Additional Director, Rajasthan State Judicial Academy. On behalf of Rajasthan High Court and Rajasthan State Judicial Academy, extend you all a very warm welcome in this law seminar on the topic, Constitutional Governance in India, Dr. B.R.Ambedkar's idea of socio-economic justice, social engineering through judicial activism, convened in continuation of Platinum Jubilee celebration. Platinum Jubilee of Rajasthan High Court marks an illustrious milestone signifying 75 years of unwavering dedication to justice and legal excellence. This year-long celebration is characterized by a series of distinguished events and activities, each meticulously curated to honor the court's remarkable legacy and profound contributions to the legal realm. The festivities commenced with a grand inaugural ceremony in Jaipur graced by Honorable Dr. Justice D.Y. Chandrachud, the Chief Justice of Supreme Court of India, esteemed dignitaries and legal luminaries. Throughout the year, a spectrum of events, including seminar, sports programs and activities, and Run for Legal Awareness with community outreach initiatives have been meticulously orchestrated, exemplifying the court's enduring commitment to uphold justice and serving the populace of Rajasthan. May I request the honorable dignitaries on the dais to please light the ceremonial lamp. Lighting a lamp is symbolic manifestation of divinity, wisdom, intellect, and good work. It is said that light conquers darkness and brings order to chaos. It is the lamp of knowledge that we always kindle in our heart, and the warmth of it not only makes us happy from inside, but also enlightens the path of others. Thank you, Lordships. With utmost honor, we extend our heartfelt welcome to the distinguished dignitaries, and as a token of our respect and admiration, we present plants embodying the essence of growth, vitality, and sustainability. So there can be no other and no better way to felicitate our honorable guest with plants. I would like to invite Honorable Mr. Justice Dinesh Mehta, Judge, Rajasthan High Court, and Chairman Working Committee of our Academy to please present the plant to Honorable Mr. Justice B.R.Ambedkar, Judge, Supreme Court of India. Thank you, Lordship. May I request Honorable Mr. Justice Vineet Kumar Mathur, Judge, Rajasthan High Court and Co-Chairman of our Academy, to please present the plant to Honorable Mr. Justice Sandeep Mehta, Judge, Supreme Court of India. Thank you, Lordship. My sincere request to Honorable Mr. Justice Birendra Kumar, Judge, Rajasthan High Court and Member Governing Council of our Academy, to please do the honors of presenting the plant to Honorable Mr. R. Venkataramani, Attorney General of India. Thank you, Lordship. May I now request Honorable Mr. Justice Manoj Kumar Garg, Judge, Rajasthan High Court, and Member Working Committee of our Academy to welcome Honorable Mr. Justice Manindra Mohan Srivastava, the Chief Justice of Rajasthan High Court and Patron-in-Chief of our Academy, by presenting him a plant. Thank you, Lordship. Mr. C.P. Shrimali, Registrar General, Rajasthan High Court, is requested to please present the plant to Honorable Mr. Justice Pankaj Bhandari, Judge, Rajasthan High Court and Executive Chairman, Rajasthan State Legal Service Authority. Thank you, sir. May I now request Mr. Kamal Chingani, Director, Academy, to please present the plant to Honorable Mr. Justice Dr. Justice Pushpendra Singh Bhati, Judge, Rajasthan High Court and Chairman, Rajasthan State Judicial Academy. Thank you, sir. In the realms of Indian Constitution governance, the ethos of Dr. B.R.Ambedkar's visionary idea for socio-economic justice intertwines seamlessly with the majestic force of judicial activism, representing a magnificent tapestry of societal transformation. His profound philosophy resonates with the dynamic nature of the Constitution, envisioned as a living document that evolves and adapts to the ever-changing landscape of societal challenges. This seminar is convened as a profound reflection on the fundamental and foundational principles of our democracy. It also serves as a poignant tribute to both the Constitution makers and its implementers' enduring legacy, and a clarion call to responsive action for the legal fraternity to uphold these principles in pursuit of a more inclusive and egalitarian society. Honorable Mr. Justice Manindra Mohan Srivastava, the Chief Justice, Rajasthan High Court and Patron-Chief of our Academy, epitomizes judicial excellence with erudition and integrity. May I now request His Lordship for the welcome address.
A very good afternoon to all. Honorable Mr. Justice B.R. Gavai, Judge, Supreme Court of India. Honorable Mr. Justice Sandeep Mehta, Judge, Supreme Court of India. Honorable Shri R. Venkataramani, Attorney General of India. Honorable Mr. Justice Pankaj Bhandari, Judge, Rajasthan High Court and Executive Chairman, Rajasthan State Legal Services Authority. Honorable Dr. Justice Pushpendra Singh Bhati, Judge, Rajasthan High Court and Chairman, Rajasthan State Judicial Academy. My esteemed brother and sister judges of the Rajasthan High Court, learned Advocate General, learned Senior Advocates, Chairman, Vice Chairman and members of the Bar Council of Rajasthan, learned members of the Bar, Presidents and Office Bearers of Rajasthan High Court Advocates Association, Rajasthan High Court Lawyers Association, Jodhpur, the Rajasthan High Court Bar Association, Jaipur and the Bar Association, Jaipur, Vice Chancellor and faculty members of National Law University, Jodhpur and other educational institutions, officers of the Registry, Rajasthan State Judicial Academy, Rajasthan State Legal Services Authority and members of Judicial Service, officers of the administration and ladies and gentlemen. It is my proud privilege to extend hearty welcome and warm felicitations to the distinguished gathering on this event of one-day last seminar, which is being organized as part of Platinum Jubilee celebration to mark 75th year of Rajasthan High Court, which was established by Rajasthan High Court Ordinance 1949 and was inaugurated in the Sun City, Jodhpur on 29th of August 1949 by Maharaja Savai Mansingh, the Raj Pramukh of the state of Rajasthan. The Raj Pramukh in his inaugural address concluded in following words, and I quote, "I would ask one and all to join with me in invoking the blessings of the Almighty on this great institution which is being inaugurated today, and it is our prayer that for all times to come in this temple of justice, truth and righteousness shall prevail, that justice be done between man and dispensed without fear or favor, and that freedom be maintained and defended," unquote. Ever since then, it has emerged as a glorious institution devoted to the cause of justice through untiring efforts of judges and the lawyers with solemn resolve to strengthen the confidence, trust and faith of the people in the judiciary and to accomplish the vision of ensuring justice for all. Committed efforts are being made to make the justice delivery system easily accessible, affordable and understandable to the common man, especially to those belonging to the poor, downtrodden, vulnerable and marginalized groups, thereby taking the institution to greater heights. Celebration of a Platinum Jubilee of any institution is a remarkable event in the history of such institution. It is also an occasion, an opportunity to introspect, learn from past experience and plan future actions and endeavor. Today's crowning event is to commemorate historic moment of establishment of a constitutional court, an occasion not only to celebrate but also to enlighten ourselves on solemn aims and objectives enshrined in the preamble of the Constitution of India, a living organic document which we, the people of India, gave to ourselves on 26th of January 1950. Understanding constitutional philosophy, principles, tenets and facets of constitutional governance is of extreme significance and importance for the judges and lawyers, the two wheels of the chariots of justice. Today's seminar is being organized for the benefit of entire legal fraternity of the state, aimed at sensitizing ourselves on some of the core values of similar importance and enlightening path of constitutional governance. As Dr. B.R.Ambedkar aptly remarked, I quote, "Constitution is not a mere lawyer's document, it is a vehicle of life and its spirit is always the spirit of age." Dr. B.R.Ambedkar's vision of socio-economic justice was rooted in the belief that equality of opportunity is essential for the upliftment of marginalized communities. His words resonate with profound wisdom when he stated, I quote, "I measure the progress of a community by the degree of progress which women have received." Ambedkar recognized that true progress lies in empowering the most vulnerable sections of society, particularly women and the socially disadvantaged. In essence, Dr. B.R. Ambedkar's vision of achieving socio-economic justice and socio-engineering through judicial activism remains a cornerstone of India's quest for a more equitable and inclusive society. His ideas continue to inspire movements for social reform, and his legacy endures as a guiding light in the ongoing struggle for justice and equality. This seminar in the Platinum Jubilee year of this august institution is going to be a memorable event with the illuminating presence of three legal luminaries, our distinguished speakers, Honorable Mr. Justice B.R. Gavai, Honorable Mr. Justice Sandeep Mehta, and Sri R. Venkatramani, Learned Attorney General of India, who would be enlightening all of us with their vast, diverse and enriched knowledge and vision of constitutional philosophy and principles touching upon theme of constitutional governance. I am beholden to each of them for having accepted our invitation and gracing this event despite their extremely busy schedule. I once again welcome all our distinguished guests, speakers, and legal fraternity, those who are sitting here, for their gracious presence. Thank you. Jai Hind.
Thank you, Lordship, for the warm welcome and for setting the tone of the seminar. Honorable Mr. R. Venkataramani, Attorney General of India, eminent in constitutional law and human rights, assumes reverence globally for his dedication to justice and legal excellence. May I request you, sir, for your address?
To be sandwiched between two honorable judges of the Supreme Court is not very different from being sitting by their side. I am extremely happy to be sitting with them who are honoring the event and the presence of the Honorable Chief Justice of Rajasthan High Court, who has been very insistent that I should be here today. I thank you for inviting me here. Celebrating 75 years of an institution is to celebrate its vitality, is to celebrate its organic evolution, and to celebrate its potential chronicles of future contributions. The contributions of high courts in our country stand second to none in terms of the vast expanse of jurisprudential spectrum. We can say with pride that the common law of our high courts are as original as the common law of England. We must continue to acknowledge and promote their role in India's constitutional journey. I am deeply privileged to be here today to share the joy and power of celebration as it is our personal celebration. A few words about the phenomenal contribution and visions of the Venerable Dr. Ambedkar. I continue to be a student of his writings. Besides the constitution-making contribution, he has extensively written on virtually everything under the sun. His thoughts on economics, the land and peasant issues as they prevail in pre-independence era, on social liberation of the oppressed, on communism, on reforms and faiths, on women's liberation, political theory, etc., are profound and original. His comments on Bertrand Russell's article on social reconstruction is a masterpiece of original thinking. He was a Nobel Prize status. It's a fitting tribute to him that our courts have been able to internalize his visions and thoughts. I consider today's celebration as also a celebration of his monumental national contributions. The system of adjudication by courts as is being practiced in contemporary times has been called a form of social ordering. In an open society, unlike a totalitarian or a dictatorial society, social ordering will connote socially acknowledged freedoms, otherwise called fundamental freedoms, social control, social regulation, and their interplay. Social control will primarily include legislation and executive actions. It can extend to faith, religion, ideology, and culture. All of them impose themselves on our freedoms. We have created institutions or forms for each one of them. All of them, in a sense, perform social tasks. While we may like to limit the influence of any one of them in order our freedoms are not controlled or impeded, in reality, I think it's because of the social tasks performed by these factors that our freedoms are intact. We, however, take this for granted. We think that all social controls are undue limitations on our freedoms. The fundamental distinctions between social control in an open society and social control in a totalitarian society are well known. The distinctions are important for vigilance on various tasks performed by different social agencies and institutions. The social ordering task being performed by courts, as noticed above, needs a close attention. An open society flourishes because it cares for and provides spaces for various social tasks to be performed. Each one of the social tasks must have their spheres demarcated. One such sphere is what we often call the separation of powers. Breaches or transgressions of the spheres will lead to imbalance in the social ordering, functioning, and social tasks. The demarcation is not a mere pen and pencil boardroom exercise or a layout plan like a town and country planning blueprint, nor is it a mere legal architecture. It's the sangamam or the confluence of our freedoms, their vital exercise, the self-imposed restraints on their exercise born out of cultural and faith influences, and the social tasks assigned to the political, judicial, and governance institutions. The demarcations become dynamic by reason of the constant adjustments and readjustments, accommodations, and relinquishments of worn-out days of the past. It is in this context that we need to take stock of the special social task spread out for courts. I wish to talk about two aspects of the two social tasks of courts. When you use the term social task of courts, we underline their connection to maintenance of social order in an open society. The organic growth of and the limits on the discharge of the special social task of courts comprehends the law of precedence and the basic structure doctrine. Coming back to the idea of an open society, it is important we notice that no ideology or faith should dominate or dictate its functioning. Ideologies and faiths can have their spaces, but as not to exclude rooms for plurality and debates. An ideology or faith which dictates everything about our mind, our thoughts, our transactions, and importantly, our creativities and innovation is antithetical to open society. Before I proceed further, I wish to look at the constant as well as changing perspectives on precedents, a few words on that. Many ancient legal systems, the Chinese, the Babylonian, the Assyrian, the Sumerian, and the Arabic were informed by precedents. This is what called in Germany, as far as late Roman law is concerned, it is said that there is a good deal of literature on the pervasiveness of precedents in various systems. Values such as certainty, uniformity, equal treatment guided this branch of law. But what if a precedent has lost its logic, relevance, and capacity to resolve disputes at a given point of time? As Lord Sumption in UK Supreme Court judge put it, I quote, "In a precedent-based system, judges do not merely discover legal principles concealed in the luxuriant undergrowth of ancient principle and scattered legal decisions, but they make law within the broad limits determined by statute and the legal policy," unquote. It is often said that common law is judge-made law, as one must keep abreast of current social conditions and expectations, and this is not like that question like, do bees make honey? For the bees, the ingredients are not of their making, but the product is different from the ingredients. So also the ingredients are not made by courts, but the products differ from the ingredients. If these elements of certainty, uniformity, etc. are indispensable features of a stable legal system, then how do we sanction and justify departures from precedents? We can look at a few statements in this regard. Many have written about the notions of common law from Holmes to Frederick Pollock. The freedom assumed by the judicial branch to find solution to new questions guided by the maxim, where there is a right, a remedy must lie, has been treated as one of the most core features of common law. The felt necessities of time, as Justice Holmes talked about, and the perfection of reason as the moving spirit behind the genius of the common law are all well inscribed in judicial pronouncements and academic writings. The story of a nation's development and its law cannot be dealt with as if contained in the axioms and corollaries of a book of mathematics, said Justice Holmes. And what is the foundation of creativity in justice administration and good and relevant in all contexts, more particularly in constitutional governance? The expression Judicial activism and judicial review are often used interchangeably, particularly in the United States, where the debates on originalism and textualism versus Constitution as a living document has long occupied the legal space. The reflections of Judge Robert Bork, who could not make it to U.S. Supreme Court, in his book, The Tempting of America, and the Supreme Court Justice Antonin Scalia's book, A Matter of Interpretation, are examples of the textualist school. The judgment of the Supreme Court of India in A.K. Gopalan is a native example of textualism. The early era of judgments in contract law that public law principles will not influence even contracts of governments or another example. Till the 80s, the locus standi and death penalty debates were either textualist or attitudinal. Our jurisprudence now is not the same as then was. We did not suffer the suffocating dry debates of textualism versus living document. We have moved into the era of vibrant constitutional exchanges. The fertile expression coined by Justice Krishnaiyer, third world remedial jurisprudence, marks the beginning of a new era in our constitutional debates in courts and in public domain. Article 21 of the Constitution is the bedrock and fountainhead of remedial jurisprudence. A 133 CRPC can be a potent tool as it happened in the case of Ratlam municipality case. Article 14 is both a sword and a shield. In the midst of globally interconnected world, and we are connected through unprecedented migration of human and other resources, I think remedial jurisprudence is one side of the coin of social ordering, task of courts, and the other side laying the line of the rail track along with governance institutions. Disjoints or cracks in the two parallel lines of national governance and social task will retard an orderly progress. It is this understanding of mutually reinforcing social task, performance, and delivery that our country can truly remain an open society. Remedial jurisprudence means removing hurdles in the legacies of law, removing social barriers to equal participation in all walks of life, reshaping public and governance institutions, and enabling the disadvantaged to access all socially generated resources. All socially generated resources are public goods, from education to employment, from economic opportunities to cultural accomplishments, are all public goods, and many more. It is important that the discharge of this complex task and the changing contours of the dynamics involved in this are given due latitude. Any ideological hijacking of the term activism as a vehicle to treat the court as an opposite party in governance or a weak partner will be undermining its real and pragmatic meaning. Perhaps if we understand that courts have a social ordering task, then the tools that the courts can fashion, the norms and principles that can be read out into constitutional expressions will not be dictated from outside, nor will court convert itself into an alternate social ordering body. Courts, as public deliberators and as adding to public reasoning, will then receive its deference. But I think we are not yet ready for this marriage. Either we talk about activism as an antidote to governmental measures or unbridled veto power. In my understanding, the parallel tracks of governance requires several changes. I must say that the wisdom of unattached engagements, of course, is a responsibility that involves and calls for knowing and balancing many entangled economic and political factors. More so when India is poised for a great movement ahead in the global roles. Many undue interventions in the use of courts have occurred. Socio-economic justice demands are different from asking the courts to engage in matters such as stray dog menace, municipal waste management, supervisor, how to convert service of summons in court proceeding, gender neutral, etc. I think these are the most trivial parts of a court's engagement. The tendency to see the court as a place for theoretical debates and to use it for ideological or partisan political ends can dilute the importance of its social ordering role. When we gather on occasions like this to take stock, we can only lay road maps and leaving the details of speed breakers, toll plazas, rain-hit potholes, wayside banyan trees and waterways as also highway motels to be drawn in due course. These are details that will emerge in their own dynamics of a journey. Creativity in science and technology is not guided by ideological persuasions or dictated by political desirability. Art and poetry may, however, seek to express philosophy or any matter about the human condition. Politically articulated thoughts may seek ever-refining frontiers and possess creative elements in looking at social issues. Law seems to position itself somewhere between these subjects. The freedom of the common law can also be seen as a phenomena of creativity in a very special sense. The question, however, will be what limitations or what boundaries will inform and guide this legal thought process. Will acting under constitutional demands call for freedom of the judicial branch to determine its own boundaries and thus an undefinable matter externally? Who will codify and practice the institutional demarcation or separation of powers? Even if the Constitution places a distinct trust and obligation on the Constitutional Court to articulate meanings and roadmaps through an interpretive process, can this process by itself become the codifying process of separation of powers? This primary constitution question, born with the idea of constitution and its answers, however, will be the Noah's Ark for a long journey towards a liberty for all. The only difference will be that the members and passengers of the constitutional Noah of India will keep changing, unlike the chosen ones in the ancient biblical ark. Our commitment to an open society is our commitment to the well-being of all, and most importantly, the deprived and the disadvantaged. Jai Bharat, thank you for your attention.
As butter between the sandwich were your words of insight about the flip side of the coin. Thank you, sir, for your eloquent address. Honorable Mr. Justice Mehta, Judge, Supreme Court of India, an integral part of the Academy, is an epitome of wisdom, lauded for his unwavering dedication to justice and promoting excellence in budding judges. May I now invite our guest of honor, His Lordship, for this special address.
क्षमा गणी पधारो मारे देश। प्रिय भ्राता आदरणीय न्यायाधीश श्री B.R. गवई और विद्वान अटॉर्नी जनरल श्री R. वेंकटरमणी का मारवाड़ की शान इस सूर्य नगरी जोधपुर में स्वागत है। ऑनरेबल जस्टिस M.M. श्रीवास्तव, चीफ जस्टिस राजस्थान हाई कोर्ट, my esteemed brothers, Justice Pankaj Bhandari, Honorable Justice Pushpender Singh Bhati, Chairperson, Rajasthan State Judicial Academy, esteemed sister and brother judges of the Rajasthan High Court, Learned Advocate General, learned senior advocates, Chairman, Vice Chairman, members of the Bar Council of Rajasthan, President and office bearers of the Rajasthan High Court Advocates Association and the Rajasthan High Court Lawyers Association, Jodhpur, the Rajasthan High Court Bar Association, Jaipur, and the Bar Association, Jaipur, members of the Bar, Vice Chancellor, and the faculty members of the National Law University, Jodhpur, and other educational institutions, officers of the registry, Rajasthan State Judicial Academy, Rajasthan State Legal Services Authority, and the members of the Judicial Service. Above all, the newly inducted batch of judicial officers, some of whom I had the good fortune to interview, who will be completing their induction training in April. Gracious ladies and gentlemen, I have been given this daunting task by Honorable the Chief Justice to speak on the constitutional vision of justice in presence of such luminaries like my esteemed brother, Honorable Justice Gawai, who I am having the good fortune of sharing the bench, who rattles off the judgments on the constitutional law as if they were written on the back of his hand. And of course, the learned Attorney General. This is, I would say, a gross injustice that I have to speak on this subject. But since my Chief Justice has given me this task, I must share a few thoughts with the august gathering. The focus of today's discussion is on those areas of the Constitution that further the vision of justice and purpose various ways and means to make this vision a reality, as well as the onus and moral duty of the Indian judiciary in upholding the constitutional vision of justice through its judicial pronouncements. Our Constitution is the fundamental law of the nation, which lays down the formation of the government, the judiciary, and also delves into the other quintessential forms and processes for ensuring that the democratic nature of this country remains intact. This very document also contains the fundamental principles according to which the state is to be governed and the mechanisms under which the laws are to be legislated within the well-defined jurisdiction enunciated under it. In the words of Dr. B.R.Ambedkar, Constitution is not a mere lawyer's document. It is a value of life, and its spirit is always the spirit of age. The idea of bringing and achieving justice in society is the foremost goal of our Constitution and an ideal for any particular society. For a vibrant democracy, we need better implementation of justice. Without the presence of justice, any society cannot develop as a constitutional society and will collapse, leading to chaos. Before delving into this topic, the term justice needs some attention. The term justice finds its genesis in the Latin expression justitia, which means righteousness or equity. Rendering justice or dispensing justice therefore means doing what is right. Justice is the quality that ensures that each person receives their rightful claim and compensation arising out of any violation or harm to his or her rights enshrined under a statute or under the Constitution. In simple terms, justice can also be understood as the correct application of law with a supply of cogent reasons as opposed to arbitrariness. Friends, a society cannot exist without justice, which is one of the most important pillars upholding the integrity of the nation. Justice can be attained in a society only by the correct interpretation and implementation of the laws and by fostering equal treatment amongst people irrespective of status, caste, etc. through such interpretation. The framers of Indian Constitution, with their far-sightedness, had the vision of inclusive justice and progress for all, and therefore, in the preamble, the term justice stands at the highest pedestal where a declaration is made regarding the commitments of the Republic. The preamble embodies the philosophy of the Indian Constitution and not only envisages order, creating an egalitarian society, but also strives to attain a social and economic order in which individuals are responsible for their actions. In our Constitution, it is the preamble that gives vital importance to justice for all. The term justice finds its place in the preamble of the Constitution, and so also the articles dealing with the fundamental rights and the directive principles of state policy. The Supreme Court, Honorable Mahajan Chief Justice, speaking for the bench in the case of Behram Khurshid noted the link between the constitutional vision contained in the preamble and the position of the fundamental rights as a means to facilitate its fulfillment. Though part third embodies the fundamental rights, this was construed to be a part of wider notion of securing the vision of justice of the founding fathers, and as a matter of doctrine, the rights guaranteed were held not to be capable of being waived. Honorable the Chief Justice Y.V. Chandrachud, in the case of Minerva Mills, traced the history of evolution of inalienable rights founded in the inviolable liberties during the course of the freedom movement, and observed the edifices of our Constitution is built upon the concepts crystallized in the preamble. We resolved to constitute ourselves into a socialist state which carried with it the obligation to secure to our people justice, social, economic, and political. We therefore put part 4 into our Constitution, containing the directive principles of state policy, which specify the socialistic goal to be achieved. We promise to our people a democratic polity which carries with it the obligation of securing to the people liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and the assurance that the dignity of the individual will at all costs be preserved. We therefore put in part 3rd in our Constitution, conferring those rights on the people. In Nagaraj versus Union of India, the Supreme Court observed, and I quote, "Economic justice means providing equal economic opportunities and ensuring economic equality in order to eliminate the concentration of wealth and glaring inequalities amongst different strata of society. The economic status of any person should not be an impediment for availing the prospective opportunities available to him. All three types of justice are closely related to each other. One cannot be attained unless and until the two other are achieved. In 2019, the 103rd Constitutional Amendment was promulgated for ensuring economic justice to the persons belonging to the EWS sections. The jurisprudence behind this amendment was the implementation of economic justice, and this amendment, as everyone knows, was upheld by the Supreme Court in the case of Janhit Abhiyan. In the case of Indian Young Lawyers Association, famous case of Sabarimala, the Supreme Court observed the Constitution as a fundamental document of governance has sought to achieve a transformation of the society. In giving meaning to its provisions and in finding solutions to the intractable problems of the present, it is well to remind ourselves on each occasion that the purpose of this basic document which governs our society is to bring about a constitutional transformation. In a constitutional transformation, the means are as significant as are our ends. The means ensure that the process is guided by values. The ends or the transformation underlie the vision of the Constitution. One of the important concepts of justice as enshrined in the Constitution is the concept of distributive justice, which means fair distribution of resources among the citizens who are in need of it. This has been elaborated in Articles 38 and 39 of the Indian Constitution, which provides a mandate to the state to secure a social order for promotion of welfare of the people. Justice D.A. Desai, in the 117th report of the Indian Law Commission, noted the role of judiciary in upholding justice in the following terms, and I quote, "On the enforcement of the Constitution in January 1950, this system was expected to adapt itself to facilitate the transformation of the Indian society into a nation and to become an effective instrument for carrying out the mandate of Article 38. Judiciary being an important instrumentality for the exercise of state judicial power, it had to shoulder the burden along with the other wings to set up a welfare state in which justice, social, economic and political shall inform all the institutions of national life. It must also shoulder the primary responsibility of eliminating inequalities in status, facilities and opportunities, not only amongst groups of people residing in different areas, engaged in different vocations. It had added the responsibility of becoming a guardian angel for the protection of fundamental rights of the citizens. Thus, from a purely colonial institution operating more or less as a wing of law and law and order enforcement machinery, it was to become a sentinel on the qui vive. Provisions relating to equal justice and free legal aid enshrined under Article 39A of the Constitution give every citizen the right to get free legal aid from the officers of the court for representing them in the courts. No one should be denied access to free legal aid. It is the duty of the state to ensure that the working of the legal system is based on justice, providing equal opportunity and free legal aid to ensure that any opportunity for securing justice is not denied to any citizen due to his or her economic or other disabilities. Articles 14, 19 and 21 of the Indian Constitution are of paramount importance in protecting the fundamental rights of the citizens and ensuring that justice is served. These three articles form the basis of democracy in India and provide that every citizen is treated equally before the law and is entitled to basic freedoms and rights such as freedom of speech, assembly and movement, and the right to life and personal liberty. The role of judiciary as the guardian and custodian of the fundamental rights of the citizen is pivotal in enforcement of all three types of justice enshrined under the preamble of Constitution. The Supreme Court in the case of K.S. Puttaswamy stated, the Constitution has evolved over time as judicial interpretation led to recognition of specific interests and entitlements. These have been subsumed within the freedoms and liberties guaranteed by the Constitution. The interpretation of the Constitution cannot be frozen by its original understanding. The Constitution has evolved and must continuously evolve to meet the aspirations and challenges of the present and future. Nor can judges foresee every challenge and the contingency that may arise in future. The judiciary has always endeavored to establish justice in the country. The approach adopted by the judiciary has been progressive in this regard, which is manifest in its decisions. Justice is an essential ingredient of a developed and law-abiding society. Unless the courts give effect to the principles enumerated under the Constitution, the vision of justice will remain only a paper formality. The Supreme Court and the High Courts, while interpreting the provisions of Constitution under Parts 3 and Parts 4, have very dynamically expanded the horizons of the fundamental rights of the citizens through various judicial pronouncements in view of the constitutional morality. The Constitution is malleable to the changing needs and ethos of the nation. The Supreme Court has expanded the scope of Article 21 to mean that life does not mean merely a physical existence. The ambit of the procedure established by law has been interpreted to mean that the procedure must be fair, just, and reasonable. This interpretation has ensured that the fundamental rights of individuals are protected and strengthened. The framers of the Indian Constitution, in order to achieve the vision of justice, inserted provisions like Article 50, which explicitly provides for separation of powers. It mandates that the state must take necessary steps to separate the judiciary from the executive in the public services of the state. This acts as a check and balance, restricting the authority's use of powers and positions unfairly for the personal gains or otherwise. The independence of the judiciary is a necessary feature of the rule of law and fundamental characteristic of the Indian Constitution for enforcing the rule of law. The nation primarily needs to have an independent judiciary as one of its integral and critical components. The decision of the Supreme Court in the case of L. Chandra Kumar upholds the power of judicial review of the legislative action as a basic feature of the Constitution of India. In the subsequent decision in the case of Dadu Ilyas Tulsidas, it was reiterated and it was held that judicial review is the heart and soul of the constitutional scheme. The Constitution has entrusted the constitutional courts as the highest courts of the land to be its conscience keepers and has vested them with wide powers. The faith of the people of India, which stands reposed in the Supreme Court and the High Courts, is manifested from the ever-growing dockets of cases in the courts. Our Constitution was drafted by the framers with the belief that the greatest good for the greatest number is compatible with protecting individual rights. Ours is a noble Constitution that provides a detailed vision of rights, machinery for their protection and promotion, and a balance between the individual rights and the society's good, as well as the state's security. The provisions of the Constitution have been expanded dynamically by the Supreme Court and the High Courts across the country so as to meet the requirements that have arisen from time to time, thereby making the provisions meaningful and relevant to the people of India. Justice Oliver Wendell Holmes stated, and I quote, "The life of the law has not been logic, it has been experience. The felt necessities of time, the prevalent moral and political theories, intuitions of public policy, avowed or unconscious, even the prejudices which judges share with their fellow men have had a good deal more to do than the syllogism in determining the rules by which men should be governed. The Indian citizenry looks up to the judiciary as an institution that can fulfill their aspirations. In the event of this not happening, it is but natural that they may try to interrogate the functioning of the judiciary. It is therefore necessary for the Indian judiciary to acquire and develop skills to discharge its constitutional obligations. I'll conclude my address with the following words. If the courts fail to carry out this mission, our democracy would fail in achieving its vision. Thank you. Jai Hind.
Thank you, Lordship, for the words of wisdom about the ethos and goals of our noble and vibrant Constitution, and the onus on every one of us to achieve a just and egalitarian society. E-repository of data and digital library are the new normal. Rajasthan High Court's innovative e-initiative, which is ready for launching, promises to revolutionize the way legal research is conducted, providing users with unparalleled access to comprehensive database of judgment of Honorable Apex Court and our own High Court, both in Hindi and English in parallel. Rajasthan High Court, in line with Honorable Supreme Court of India's free and open access ESCR and accomplishing the objectives of AI assisted legal translation advisory committee's goal, has developed a user-friendly, comprehensive, updated bilingual judgment search portal, e-law reports Rajasthan,
मातृभाषा हमारे सामूहिक इतिहास, मूल्यों और आकांक्षाओं का प्रतिबिंब होती है, जो हमारी परंपराओं और ज्ञान को संरक्षित कर उन्हें एक पीढ़ी से दूसरी पीढ़ी तक पहुंचाती है। क्षेत्रफल व जनसंख्या की दृष्टि से वृहद और विविधताओं से परिपूर्ण राजस्थान राज्य की आधिकारिक और जनभाषा हिंदी है। सर्वोच्च न्यायालय और उच्च न्यायालय की आधिकारिक भाषा अंग्रेजी होने से आज भी न केवल राजस्थान राज्य बल्कि अन्य राज्यों जैसे उत्तर प्रदेश, मध्य प्रदेश, बिहार, झारखंड, छत्तीसगढ़, दिल्ली, हिमाचल प्रदेश, उत्तराखंड आदि हिंदी भाषी राज्यों के छोटे छोटे गांवों, कस्बों व ढाणियों के पक्षकार अपने मामलों के आदेशों व निर्णयों को जानने समझने में स्वयं को असहाय पाते हैं। ऐसे में सर्वोच्च न्यायालय के मुख्य न्यायाधीश माननीय डॉक्टर D.Y. चंद्रचूड़ साहब के दिशा निर्देशन में ई कमेटी ने सर्वोच्च न्यायालय और समस्त उच्च न्यायालयों के निर्णयों को देश की विभिन्न क्षेत्रीय भाषाओं में अनुवाद करने का बीड़ा उठाया है। राजस्थान उच्च न्यायालय ने भी लगभग 4000 से ज्यादा निर्णयों का हिंदी में अनुवाद कर अपनी वेबसाइट पर प्रकाशित कर विधिक सशक्तिकरण में अपना योगदान दिया है। इसी क्रम में एक और कदम बढ़ाते हुए अपने प्लेटिनम जुबली वर्ष में आज राजस्थान उच्च न्यायालय माननीय अतिथिगण की गरिमा में उपस्थिति में प्रकाशन के पारंपरिक तरीके को डिजिटल रूप से प्रतिस्थापित करते हुए इलेक्ट्रॉनिक लॉ रिपोर्ट राजस्थान अर्थात ELR राज पोर्टल को लॉन्च कर न्यायिक प्रक्रिया के विभिन्न हितधारक पक्ष यथा न्यायाधीश, अधिवक्ता, पक्षकार, पुलिस, प्रशासन इत्यादि के साथ साथ विद्यार्थियों और आम जन को भी एक महत्वपूर्ण विधिक सौगात देने जा रहा है। ये पोर्टल हिंदी भाषा में निर्णय व आदेशों की अवधारणाओं को आसानी से समझने के लिए उक्त सभी हितधारकों को सशक्त बनाएगा, जिससे विधिक विरासत के लिए गहरी समझ को बढ़ावा मिलेगा। आइए इस पोर्टल की कुछ महत्वपूर्ण विशेषताओं पर नजर डालें। राजस्थान राज्य से संबंधित सर्वोच्च न्यायालय के महत्वपूर्ण निर्णयों और राजस्थान उच्च न्यायालय के रिपोर्टेबल निर्णयों को एक ही पोर्टल पर उपलब्ध कराया गया है। ये पोर्टल सभी के लिए निःशुल्क है और किसी भी पंजीयन प्रक्रिया या अन्य औपचारिकताओं से मुक्त है। निर्णयों को न्यायालय व न्यायाधीशों के नाम, प्रकरण व पक्षकारों के विवरण, निर्णय की दिनांक आदि के साथ साथ फ्री टेक्स्ट सर्च के माध्यम से भी ढूंढा जा सकता है। बेहतर सर्च रिजल्ट के लिए सर्च विद इन सर्च की सुविधा भी दी गई है। पोर्टल का प्रारूप हिंदी व अंग्रेजी दोनों भाषाओं में बनाया गया है और इसके साथ साथ न केवल निर्णय बल्कि सर्च करने की सुविधा को भी दोनों ही भाषाओं में उपलब्ध कराया गया है। संभवतया ये हिंदी भाषा में निर्णयों को सर्च करने का स्वयं में एक अनूठा और प्रथम प्रयास होगा। सर्च रिजल्ट में आए निर्णयों के साथ संक्षिप्त हेडनोट भी दिए गए हैं। निर्णयों को हिंदी व अंग्रेजी दोनों भाषाओं में डाउनलोड व प्रिंट करने की सुविधा भी उपलब्ध कराई गई है। इस प्रकार भारत के हिंदी भाषी राज्यों की लगभग 53.74 करोड़ की आबादी, जो कि भारत की कुल जनसंख्या का लगभग 40% है, उक्त पोर्टल से निश्चित ही लाभान्वित होगी। पोर्टल को उपयोग में लेने की प्रक्रिया अत्यंत ही सरल है। इसके लिए किसी भी वेब ब्राउजर की एड्रेस बार में URL https://hcraj.nic.in/ELR-raj टाइप करें या राजस्थान उच्च न्यायालय की वेबसाइट पर होम पेज पर दिए गए ELR राज टैब पर क्लिक करें। उक्त पोर्टल का होम पेज हिंदी भाषा में होगा, जिसे दाईं ओर उपलब्ध कराए गए ड्रॉप डाउन बटन से अंग्रेजी भाषा का चयन कर अंग्रेजी में निर्णय आदेश सर्च किए जा सकते हैं। वांछित निर्णय से संबंधित सर्च पैरामीटर का विभिन्न खोज मापदंडों में चयन करें। कैप्चा कोड अंकित कर सर्च बटन पर क्लिक करें। इस पर नीचे खोज परिणाम बॉक्स में सर्च पैरामीटर से संबंधित निर्णयों की सूची दर्शित होगी, जिनके साथ निर्णय का विवरण और संक्षिप्त हेडनोट भी होगा। उक्त निर्णयों की सूची को अन्य सर्च पैरामीटर का उपयोग कर आगे और भी फिल्टर किया जा सकता है अथवा किसी सर्च पैरामीटर को हटाकर सूची का विस्तार भी किया जा सकता है। वांछित भाषा में निर्णय खोलने के लिए भाषा के ड्रॉप डाउन बटन से हिंदी या अंग्रेजी का चयन करें। निर्णय के शीर्षक पर दिए गए लिंक पर क्लिक करें। निर्णय को फुल स्क्रीन पर देखने, डाउनलोड करने या प्रिंट करने के लिए पॉपअप विंडो पर दिए गए विकल्पों का प्रयोग करें। आशा ही नहीं अपितु विश्वास है कि यह पोर्टल, जो कि अभी शैशव अवस्था में है, सतत अनुवाद प्रक्रिया और परिष्करण से विकसित होकर न केवल हिंदी भाषा में विधिक जागरूकता का सशक्त माध्यम बनेगा, बल्कि विधिक अन्वेषण के क्षेत्र में भी एक मील का पत्थर साबित होगा, जो सभी हितधारक पक्षकारों को लाभान्वित करेगा। धन्यवाद।
Ladies and gentlemen, what you saw just now was the demo of a live web portal of the e-law reports. Honorable Mr. Justice B.R. Gavai, Judge Supreme Court of India, a stalwart of judiciary, is renowned for the astute legal acumen and prolific judgments. May I now invite His Lordship for the keynote address.
My esteemed brother, Honorable Justice Sandeep Mehta, the Honorable Shri R. Venkatramani, the Attorney General for India, Honorable Mr. Justice Manindra Mohan Srivastava, the Honorable Chief Justice of the Rajasthan High Court, Honorable Mr. Justice Pankaj Bandari, the Judge of the Rajasthan High Court and Executive Chairman of Rajasthan State Legal Services Authority, Honorable Dr. Justice Pushpender Singh Bhatti, Judge Rajasthan High Court and Chairman of the Rajasthan State Judicial Academy, my esteemed colleagues from the Rajasthan High Court sitting in the audience, the Learned Advocate General for State of Rajasthan, the respected senior advocates, Chairman, Vice Chairman and members of the Bar Council of Rajasthan, the President and Office Bearers of the Rajasthan High Court Advocates Association and Rajasthan High Court Lawyers Association Jodhpur and the Rajasthan High Court Bar Association Jaipur and the Bar Association Jaipur, the learned members of the Bar, the learned Vice Chancellor of the National Law University Jodhpur and the other faculty members, the Director of the Academy and the other faculty members, the officers of the Registry, Rajasthan State Judicial Academy, Rajasthan State Legal Services Authority, and members of the Judicial Service, the officers of the administration, and last but not least, the young judicial officers who are the future of the Indian judiciary, present here, and friends. It gives me a great pleasure to be with you on the auspicious occasion of the Platinum Jubilee celebrations of the Rajasthan High Court. For an institution to enter into a 75th year, and it's a really important milestone. It's a matter of great coincidence that your Platinum Jubilee is coterminous with the Platinum Jubilee of the Indian Constitution. The Indian Constitution on 26th of January 1950 has completed 74 years, and we are now in the 75th year and will be completing our Platinum Jubilee on 26th of January next year. So I must at the outset congratulate the Honorable the Chief Justice and all my colleagues, including Justice Mehta, who is also a part of the Rajasthan High Court, for entering into the Platinum Jubilee celebrations. I'm really happy that the Rajasthan High Court in this year-long celebrations is holding various programs to commemorate the Platinum Jubilee celebrations. As a part of that program, I am really happy to be with you this afternoon. I was really also happy to inaugurate the e-portal as well as the ESR at the High Court building and the Nyayapath, which leads from the National Highway to the Academy. Justice Mehta was saying that the entire road from here to the Jodhpur High Court is likely to be renamed as a Nyayapath, and it's, I think, one of the rare events in the country that any road must be named after the justice. We are assembled here for a day-long seminar on the constitutional governance on India. The Honorable Chief Justice had given me the subjects, two subjects, one on the constitutional governance and the other one was on precedents. But since we are celebrating our Platinum Jubilee of the Indian Constitution also, I thought it appropriate to choose the first topic. In this topic, we will be also covering the idea of Dr. B.R.Ambedkar, who is the main architect of the Indian Constitution on socio-economic justice, and the role of this court in social engineering through its jurisdiction of judicial activism. In fact, after the erudite arguments of the learned Attorney General and the scholarly erudition of my learned brother, I could have easily said, I accept the arguments of the learned Attorney General and concur with the views taken by my learned brother. But since you have called me all the way from Delhi, I will try to share my views with you on this important topic. As all of us know, that prior to 1947, before the India gaining its freedom, we had to wage a long war spread over centuries for getting freedom. At the same time, India also witnessed the revolution for socio-economic injustice that was prevalent in the country for ages together on account of social reasons as well as the economic inequalities. And therefore, when the Constitution was framed, it was framed in this background of the freedom struggle as well as the struggle for socio-economic revolution. For considering today's topic, we'll have to consider the constitutional journey as to how certain amendments have taken place to the Constitution, and as well as the role played by the judiciary in this aspect. Dr. Ambedkar always considered a constitution as a weapon for bloodless revolution. He always said that the Constitution is a means to achieve a social and economic justice in this country. As a matter of fact, when the Objectives Resolution was placed before the Constituent Assembly in December 1946, on 13th of December 1946, by Pandit Jawaharlal Nehru, the Objectives Resolution is the basis on which our preamble is enacted. And when Dr. Ambedkar spoke in the Constituent Assembly on 17th of December, 4 days after the Objectives Resolution was placed, he said, coming from a person like Pandit Jawaharlal Nehru, I am not happy with the Objectives Resolution. There is no emphatic statement with regard to social and economic justice in the Objectives Resolution, and also, though the Objectives Resolution provides for rights, it does not provide for remedy. And he stated that the rights without remedy are meaningless. And therefore, we find that the very foundation of Article 32, which is the power of the Supreme Court to issue writs, and the power of the High Courts under Article 226 finds its roots in the first speech of Dr. Ambedkar on 17th of December. All of us know, after elaborate discussion for spreading over for more than 2 years and some months, the final draft of the Constitution was placed by Dr. Ambedkar before the Constituent Assembly. That draft was thoroughly debated, and after the debates were over, Dr. Ambedkar finally gave his reply to those debates, and his concluding speech on 25th of November 1949, a day prior to which we have adopted the Constitution, will reflect on his various thinkings, ideologies on the Constitution. As a matter of fact, his speech of 25th November 1949 itself is a subject for some good lecture, but when I am invited only to speak to the students here, I will reserve that, because before such a erudite gathering consisting of High Court judges and my learned brother, I would not like to encroach upon their times. And after Dr. Ambedkar replied to the debates, he gave a warning. In his speech, he states that tomorrow we will be achieving a political democracy. But political democracy without social democracy is meaningless. And therefore, we want that unless we also establish political democracy or social democracy in the country, the political democracy will be of no use. And he asked the question, what is a social democracy? And he himself replied, social democracy is a way of life where liberty, equality, and fraternity form the basis. And he said, liberty, equality, and fraternity not in isolation, but together. He said that if liberty is divorced from equality, it will be like a laissez-faire, a supremacy of the persons who are powerful over the persons who are weak. And he says if equality is divorced from liberty, if all persons are made equal, then it will lead to lack of initiative amongst the individuals to excel. And he therefore said that liberty and equality together are required for a social democracy. And a fraternity is required like a policeman. Fraternity will act like a policeman wherein the liberty and equality will coexist in furtherance of the goal of social democracy. And he wants that tomorrow, on 26th of January 1950, that was the date on which the Constitution was to come into effect. On 26th of January 1950, we will be entering into an era of contradictions. On a political plane, we will have a democracy, we will have an equality by virtue of one person, one vote, and one value. But what about economic and social equalities? What about social and economic justice? And he said that on a social plane, we have a society divided into graded compartments. And such compartments wherein one cannot travel from one compartment to other. And on an economic plane, we have a society wherein the vast economic wealth of the country is concentrated in few hands, and the vast majority finds it difficult to meet two ends, to have 2 meals in a day. And we therefore want that unless we eradicate these inequalities, the edifice of democracy, which we have so laboriously built, would collapse like a house of cards. And therefore, we find that we have Chapter 3, Part 3 and Part 4 in the Constitution. Part 3 deals with the fundamental rights. Dr. Ambedkar was of the view that Part 3 itself was not sufficient to achieve the goal of economic and social justice. And therefore, we have Part 4 in the Constitution, the directive principles of state policy. As all of us know that the directive principles of state policy are not enforceable in law, but the parliament and the legislature and the executive, while making the laws and while discharging their duties, are required to follow them. And therefore, we find that from very inception, as the law developed, as various amendments in the Constitution were enacted, there was always a sort of struggle between the fundamental rights and the directive principles. And many of the earlier judicial pronouncements gave rise to various amendments in the Constitution, particularly between 1950 and 1971. And those amendments and those judicial pronouncements would also be very relevant to throw light on the journey of social and economic justice in this country. One of the very first cases was the case of Champakaran Dorai-Rajan versus the government of Madras. The government of Madras had issued a government order wherein it provided a reservation for backward classes and scheduled castes. The same came to be challenged before Madras High Court. The Madras High Court struck down the said GO on the ground that it was violative of Article 14 because it hurt the equality clause. The same came to be challenged before the Honorable Supreme Court. The Supreme Court Constitution Bench, consisting of 7 honorable judges, upheld the judgment of Madras High Court. And it was held that the fundamental rights are so sacrosanct that by no executive action, by no judicial action, by no legislative action, they could be affected. Then during the same period, between 1947 to 1950, various legislatures in the country had enacted certain land reform laws, the Agricultural Land Ceilings Act, the Agricultural Tenancy Acts, and so on. They came to be challenged before various high courts. The Patna High Court had upheld the abolition of the Jamindari Act. The Nagpur High Court had also upheld the same, but some other high courts held such laws to be violative of Article 14 of the Constitution of India and Article 31 as it existed then. And therefore, these two judicial pronouncements, there was uncertainty because some high courts had taken a view that the laws made in furtherance of the promise of social and economic justice were sustainable in law, whereas some high courts had taken a view that they are not sustainable. And therefore, we find that in 1951 itself, the first amendment came to be incorporated in the Constitution. The objectives, the SOR of the said resolution was signed by none else than Pandit Jawaharlal Nehru. And to overcome the decision on Champakaran Dorai-Rajan, Article 15(4) came to be added to the Constitution. And insofar as the land reform acts are concerned, by the 1951 amendment, Article 31A was introduced, which provided that if there was an acquisition of land, etc., the same could not be declared invalid only on the ground that it violated fundamental rights. Then Article 31B provided for validation of such laws, and it also provided for the 9th schedule and granted protection to the laws which were enacted, which were included in the 9th schedule. By the said amendment, the 13 enactments were included in the 9th schedule. The said constitutional amendment came to be challenged on the ground that it was violative of Article 13(2). As all of us know that Clause 2 of Article 13 prohibits any laws if it is in contravention of any of the fundamental rights. The same came to be challenged in the case of Shankari Prasad Singh Dev versus Union of India. The challenge to the said amendment was negated by the Constitution Bench. The court held that the powers of the Parliament to amend the Constitution are unaffected by Clause 2 of Article 13, since the prohibition under Clause 2 of Article 13 was only restricted to laws, and the Constitution was not a law within the meaning of Article 13(2). In the same period, during 1954-55, there were some other judgments of the Supreme Court. The first one was the state of West Bengal versus Subodh Gopal Bose and the state of West Bengal versus Bela Banerjee, wherein the laws which provided for acquisition of the lands by providing bigger compensation came to be challenged. Then in the case of Dwarkadas Srinivas versus Solapur Spinning and Weaving Limited, the Maharashtra state had passed a legislature, then Bombay state had passed a legislature acquiring the Solapur Spinning and Weaving Limited company without paying any compensation. The Supreme Court in all these three cases held that acquisition of such properties by paying bigger compensation was leading to deprivation of a property without adequate compensation and therefore violative of Article 31 as well as 14 of the Constitution of India. To overcome these judgments, the Fourth Amendment to the Constitution was incorporated in 1955. By the said amendment, Clause 2 came to be added to Article 31. It prohibited challenge to the enactment of any law which was enacted for the purpose of acquisition of land for public purpose on the ground that the compensation so provided was inadequate. Similarly, Article 31A was also amended. The Clause 1 was substituted and it granted protection to any law with regard to acquisition of any estates, zamindaris, etc. And a challenge to the same was prohibited on the ground that they are inconsistent with or take away or abridge the fundamental rights guaranteed under Part 3. Then there was a 17th Amendment in 1964 which expanded the scope of estate. It included Jagirs, Munsifs, Jangam rights, Rayatwaris, etc. within the scope of the estate. By the said amendment, 44 more acts were included in the 9th schedule. This came to be challenged again in the case of Sajjan Singh versus State of Rajasthan, and for the first time we see a sort of dissent in these judgments. The three judges led by Chief Justice Gajendra Karkar held that the Parliament was competent to make the law which also took away the fundamental rights. Justice Gajendra Karkar, speaking for the three judges, held that if you hold that the Parliament has no powers to enact or amend the Parliament in order to meet the challenges arising out of socio-economic progress and development, then we will be taking a rigid view. He took a view that the Constitution is not a static document, but it's an organic document. It's developing and it's evolving. And therefore, in order to meet the challenges arising out of socio-economic changes, socio-economic requirements, the Parliament had unbridled power to amend the Constitution. Justice Hidayatullah and Justice Mudolkar disagreed with the said view. Justice Hidayatullah observed that I would require a stronger reasons than given in Shankari Prasad Dev to hold that the Parliament also has a power to amend the Constitution in such a way that it takes away the fundamental rights. He states that fundamental rights are the promise given by the Constitution makers at the framing of the Constitution, and therefore he dissented with the view taken by the majority. Justice Mudolkar, he also disagreed, and he held that the very word amend would stipulate that the Parliament may have a power to amend the Constitution, but if by such amendment, if the basic features of the Constitution are changed, then whether The question is whether it will be only an amendment or it will travel beyond that. And therefore, the concept of basic structure that is evolved in Keshavanand Bharati finds its root in the judgment of Justice Mudolkar in Sajjan Singh. In the meantime, the Mysore and Punjab Land Reforms Acts were also included in the 9th schedule, and they came to be challenged in the case of I.C. Golaknath versus the state of Punjab. The matter was heard by 11 judges, and by a thin majority of 6-5, the Supreme Court held that the Parliament does not have a power to amend the Constitution which takes away the fundamental rights or abridges the fundamental rights. It was held that the amendment to the Constitution was also a law, and therefore the prohibition as incorporated under Clause 2 of Article 13 was equally applicable to the amendment of the Constitution. Justice Subbarao, speaking for the majority, observed that an unanimous vote culminated into a bill of a parliament taking away the fundamental rights would also be not permissible in law. At the same time, the then government had nationalized the banks, and the nationalization of bank, that is taking away the shares of the shareholders by paying meager compensation, came to be challenged in the famous case of bank nationalization, popularly known as Rustom Koper versus the Union of India. The government had also taken away the privy purses of the then princely states, and that was challenged by His Highness Maharaja Dhiraja Madhavrao India versus Union of India. The Supreme Court, relying on Golaknath, allowed both these petitions, and it was held that the nationalization of bank, which was a result of payment of meager compensation for purchasing the shares, was violation of fundamental rights, was violation of the right to property. So also the taking away privy purses was violation of the fundamental rights of the princely rulers, and as such those decisions set aside the bank nationalization as well as taking away the privy purses. To overcome all these difficulties, we see various amendments in short period. 24th Amendment was inserted, by which Clause 4 came to be inserted in Article 13, which, and correspondingly an amendment was effected to Article 368. It was inserted so as to provide that the prohibition under 13(2) would not be applicable to the amending powers of the Constitution. Similarly, 368 provided that the prohibition under 13(2) would also not be applicable to the amending powers of the Constitution. Then, thereafter, a 25th Amendment was affected, by which Article 31C came to be inserted in the Constitution. It provided that any laws made in furtherance of Clause B and Clause C of Article 39 would not be amenable to challenge on the ground that it abridges, takes away the fundamental rights of the citizens. As all of us know, Clause B provides that the ownership and control of the natural resources of the community are so distributed so as to best serve the common goal economically. Similarly, Clause C prohibits the concentration of wealth in few hands and requires that the wealth has to be so distributed so that it will subserve the common purpose. As my learned brother Justice Mehta has rightly pointed out, these are the articles which provide for distributive justice, social and economic distributive justice in the Constitution. Then Article 31(2) also was substituted. It provided that no person's land shall be acquired except for public purpose and without an authority of law which provided for principles of determination of compensation. The second part of 31(2) provided that no such law which was enacted for compensation of land shall be questioned in any court on the ground that it abridges or takes away the fundamental right. Then by 26th Amendment, to overcome the judgment in the case of Madhavram Scindia, the 26th Amendment was inserted on 28th of December 1971. It provided for cessation of recognitions granted to princely states and abolitions of the princely states. Then by 29th Amendment, 2 more acts from the state of Kerala, that is the Kerala Land Reforms Act, and another act were inserted in the 9th schedule. The same came to be challenged in the case of Keshavanand Bharati versus the state of Kerala. In the last year itself, we celebrated a golden jubilee of Keshavanand Bharati. It is the most important milestone in the journey of the Indian Supreme Court. In Keshavanand Bharati, again, by a thin majority of, as a matter of fact, in Keshavanand Bharati, insofar as the amending powers of the Constitution are concerned, there is a virtual split. The 6 honorable judges take a view that the Parliament has an unamended, unbridled power to amend the Constitution, whereas the 6 other judges take a view that the Parliament's power to amend the Constitution are restricted. It has no power to amend the Constitution, which takes away the fundamental rights of the citizens. Chief Justice Sikri and 5 others held that there was an implied and inherent limitation on the Parliament to amend the Constitution, whereas Justice A.N. Ray and 5 others took a view that there was no limitation on the amending powers of the Constitution, and it also had a power to amend the Constitution so that it takes away the fundamental rights of the citizens. However, it is the view of Justice H.R. Khanna, which is partly accepted by 6 on one hand and 6 on the other hand, which is the view of the Keshavanand Bharati. Justice Khanna held that though the powers of the Parliament are not restricted, but it has no power to amend the Constitution in such a way which takes away the basic structure of the Constitution. But he, however, held that the Parliament also has a power to take away the fundamental rights, and he gave various enactments, various instances as to what would be the basic structure, like the supremacy of the Constitution, the secular character of the Constitution, the republic and democratic form of the government, separation of powers of 3 wings, that is the legislature, judiciary and the executive, the federal character of the Constitution, and so on. There have been various additions to those aspects. They are all enumerative and not exhaustive. Securing the dignity of individual, duty to construct a welfare state as provided in directive principle of the state policy, maintaining unity and integrity of the nation, building an egalitarian society, and so on. But the most important aspect in the Keshavanand Bharati is that though there is a virtual split insofar as the amending powers of the Constitution are concerned, the Keshavanand Bharati did away with the conflict which was between the fundamental rights and the directive principles. All the earlier judgments were of the view that wherever there is a conflict between the fundamental rights and the directive principles will have to give way to the fundamental rights. In view of conflict, it is the fundamental rights which will prevail over the directive principles. But all the honorable judges in Keshavanand Bharati said that there was no conflict between the directive principles and the fundamental rights. It was held that the fundamental rights have a place of pride in the Constitution. However, the directive principles also have a place of permanency in the Constitution so as to achieve the mandate of political, economic and social justice. Like Dr. Chief Justice Chandrachud said that the directive principles and the fundamental rights together are the conscience of the Constitution. It was held that the proper harmony between the directive principle and the fundamental right is the soul of the Constitution. It was held that the directive principles and fundamental rights were like two wheels of a chariot. You snap one wheel, the efficacy of the other would already come to a standstill. And therefore, we'll find that insofar as the vision of Dr. Ambedkar in achieving social and economic justice is concerned, there is a paradigm shift from the judgment of Keshavanand Bharati, 1973 onwards, and thereafter the journey of the Indian Constitution has always been towards achieving the goal of political and economic justice. After the judgment of Keshavanand Bharati was pronounced in 1973, we have seen that there have been many enactments insofar as furtherance of the social and economic justice is concerned. Various land reform enactments have been enacted, they have been challenged, and the Supreme Court, in view of Article 31C and 39B and C, has upheld all those enactments. In the case of Vaman Rao versus Union of India, the Agricultural Land Ceiling Act came to be challenged on the ground that it takes away the fundamental right of the citizens. Their properties are forcibly taken away. But Justice Chandrachud, speaking for the bench, states that the enactment was in furtherance of the principles enunciated in Clause B and Clause C of Article 39. It was a step towards a distributive justice. The land taken from the landholders who were having vast stretches of land, and the purpose was to distribute it amongst those who do not have lands, and therefore it was entitled to protection. In the further case of State of Karnataka versus Rangnath Reddy, wherein the transport services were nationalized, it was again sought to be argued that it was contrary to fundamental rights, and the nationalization of transport has nothing to do with the distributive justice. The same was also challenged in the case of State of Tamil Nadu versus Abu Kabir Bhai. The Supreme Court held that the distributive justice does not merely mean take away and distribute amongst the others. He said that there are various means and ways by which the distributive justice could be implemented. It was said that a private transporter would run the services only on the routes where there is a profit, and he would not render the services to the areas remote areas where there is no profit. It was therefore held that taking away the buses from the owners and using it for the transport so that the persons in the remote areas could also have a public transport was one of the ways of achieving the distributive justice. In the case of State of Maharashtra versus Basantilal Khetan, the enactment which provided for acquisition of land for housing houseless was also challenged on the ground that it has nothing to do with 39B and C. Again, the challenge came to be rejected on the ground that the land was acquired so that the houses could be built for the persons without house, without shelter, and therefore the amenities could be provided for them, the schools could be provided, and therefore it was also one of the means to achieve the distributive justice. The Supreme Court has gone further in various cases that even an enactment wherein there was no declaration that the act was saved under Article 31C, still it was the duty of the court to see what is the object of the act, and if the object of the enactment had a nexus with Clause B or Clause C of Article 31, then in spite of non-mentioning of the protection, still such an enactment was entitled to be protected. In the case of Maharashtra State Electricity Board versus Thana Electricity Supply, and so also in the case of Tinsukia Electric Company, the electricity generation plants were compulsorily acquired. The same also were challenged. The Supreme Court held that the private electricity plants would distribute the electricity only for the purposes of the profit, and therefore the downtrodden persons, the persons from the lower strata of the society, would not be able to get the electricity, and therefore an attempt to provide electricity to such classes at affordable prices was also one of the means of the distributive justices. And there are various other cases. I think I am already running out of time, and therefore I would not like to take you to all of them. Then we also see that on the labor front also, the various enactments have been enacted by the Parliament, by the state legislatures, and such enactments have been upheld by the apex court of the country. In the case of Vijay Cotton Mills, the Minimum Wages Act, a notification issued under the Minimum Wages Act came to be issued. It was argued on the ground that when an employer is in a position to get an employee for ₹10, why should he be compelled to pay 20? But the Supreme Court rejected the said contention. It was held that an employer may have a right to acquire the services of an employee, but he has no right to treat him as a slave. The promise under Article 43 cannot be an empty formality, and therefore if a Minimum Wages Act provides for a notification which provides for minimum wages which are necessity to live as a human life, then the same challenge cannot be permitted. As my learned brother rightly pointed out, that the right to life as guaranteed under the Constitution is not a right to live like an animal. A right to live has been interpreted to live a right to life with dignity, and therefore in the subsequent cases also, like the Standard Vacuum Refining and Company Limited versus Workmen, Justice Gajendra Khadkar provided that the minimum wages should constitute various factors like the diet for 4 members in the family, the nutritious diet, then the certain number of clothing so as to provide clothes for the 4 members in the family, the rental for the shelter, and so on. Subsequently, again in the case of Workman versus Reporticos and Company, the Supreme Court also added that the minimum wages should also include the cost of education of the workmen, the provision for leisure, the provision for medical health, and so on. And therefore we find that the journey has always been forward. As all of us know that in the Indian society, the women were treated as the most neglected part of the society. Savitribai Phule and Mahatma Jyotiba Phule had to fight with the society so as to provide for basic education to the women. And therefore we have special provisions in our constitution for women empowerment. And the Supreme Court, insofar as the rights of women is concerned, has always acted on a positive note. You must be knowing about a very famous case of Nargis Mirza versus the Union of India, wherein the regulations prohibited a flight attendant from becoming pregnant and giving a birth to a child. And Justice Krishna Iyer came down heavily on such a policy that if a man can bear a child and if he can continue in the service even after he becomes a father, why should a woman whose natural instinct is to become a mother be deprived of her motherhood? And the regulation came to be set aside. Then in the various other cases, the special provisions for women were challenged on the ground, on the reverse ground, that they are discriminatory because they provide a special treatment to the woman and therefore they are violative of Equality Clause under Article 41. The court held that a special provision for women was what is contemplated under the Constitution, and any special provision for women empowerment would be not hit by Article 14, rather it will be protected even by Article 14. Then we now see that women are everywhere. We have 70% in your batch. So it's really a matter of great pride that the batch consists of 70% of women. Incidentally, we have two couples here amongst our High Court judges. It must be very rare that the High Court is having two couples. And therefore, we see that now women are fighting even in the Ladakh border. They are in the glacier. They are in this year's 26th January Republic Day parade. All the contingents were led by women. The parade was led by the women. And therefore, we see that from 1950 to 70 to 24, there has been a huge change insofar as the women empowerment in the country is concerned. We have had the Prime Minister of the country who is a woman. We have two presidents who are women, and every walk of life. We had also a Lok Sabha speaker who was a woman. And therefore, the Constitution has always acted in a forward manner. The courts have acted in a forward manner. Insofar as the scheduled caste, scheduled tribe and OBCs are concerned, also there has been a paradigm change. The earlier view was that Clause 4 of Article 16 was by of an exception to Article 16, and therefore the provisions made for the upliftment of the scheduled caste, scheduled tribe, backward classes were special provisions. However, the said view which was taken in Devdasan got subsequent change. In Balaji, Chief Justice Gajendra Gadkar, speaking for the bench, said that Article 46 puts a charge on the Constitution to make special provisions for the scheduled caste, scheduled tribes and backward class of the citizens. Subsequently, in the case of N.M. Thomas, the 7 judges bench held that Article 4 is not by of an exception. The provision of reservation is implicit in the clause in Article 14 and Clause 1 of Article 16 itself. It said that the equality does not mean equality amongst everyone. It is said that if equal treatment is provided to everyone, it will lead to nothing else but then to perpetuate inequality. And therefore, providing unequal treatment to unequal treatments was the way forward to achieve the equality as promised in Article 14 of the Constitution. And therefore, we find that the subsequent judgments, including the judgment like the in the famous judgment in the Mandal case, Indira Sawhney versus Union of India, it also upheld the provisions of reservation. It was sort of a reverse discrimination or a protective discrimination. In the case of Lingappa Pochamba was Appalwa was a state, the enactment which provided for restoration of the lands to the scheduled caste and scheduled tribe came to be challenged. It was challenged on the ground that it was violative of the right to property as well as violative of Article 14. Justice A.P. Sen, rejecting the argument, held that the special provision for the scheduled caste and scheduled tribe and OBCs was implicit in the Constitution. The lands of such helpless persons were grabbed by the persons in power, and therefore an act which provides for restoration of the land to such persons was in the furtherance of social and economic justice. Since today's topic is also with regard to the role of courts in the social engineering, we see that the Supreme Court under Article 32 and the High Courts under Article 226 have evolved various rights which at the time of inception of the Constitution could not have been construed to be fundamental rights. As a matter of fact, in the case of Maneka Gandhi versus the Union of India, the court held that the fundamental rights enumerated in Part 3 are not restrictive. It was held that they are only enumerative, and anything which flows from the trinity of Article 14, 19 and 21 will have to be construed to be a fundamental right. And therefore we see that various rights have been evolved by the Supreme Court, by the High Courts to be the fundamental rights. In the case of Bandhuwa Mukti Morcha, on a postcard, the Supreme Court took cognizance of the plight of the workers working in the mines and issued various directions for their upliftment, for their protection, for their health. In the learned Attorney General referred to the case of Ratlam Municipal Council. Justice Krishna Iyer came down heavily on the practice in the Ratlam Municipal Council of a human being carrying an excreta of another human being. And therefore, we further find that various rights like right to food, right to shelter, right to live an environment, right to live in a non-polluting environment, right to drink a potable water, all such rights are evolved by the court in the process of its role as a judicial activism. In the series of cases of MC Mehta, various directions have been issued by the court, like the polluting buses were required to be shifted out of Delhi. The polluting industries were directed to be shifted out of Delhi, and therefore we find that in Delhi it's only the CNG buses and the electric buses which ply. The directions issued in MC Mehta also protected the environment in the Doon Valley, so also the Taj Mahal at Agra. Coincidentally, my learned brother Justice Sandeep Mehta and me are presiding over the popularly known as Green Bench T.N. Godavaranam case, and we have had the pleasure and opportunity of issuing various directions in the furtherance of the protection of the environment, because the resources of today should not be exhausted today. We hold them in trust for the tomorrow's generation, and therefore, whenever, no doubt that the development has to be taken, but the development has to be sustainable. The development has to be in such a way that the resources of the nation, the scarce resources, are kept intact for the future generation. Likewise, in the case of Paschim Bengal Khet Mazdoor Sangh, the court recognized the right to get a free medical treatment at the earliest. That was further amplified in the case of Parmanand Katra, relying on Article 47. And therefore, if you find at the journey of last 74 years, we'll have to come to a conclusion that the journey of the executive, the journey of the parliament, and the journey of judiciary has always in furtherance of achieving the social and economic justice. On account of various enactments which has been upheld by the Supreme Court or the other courts, lakhs of acres of land has been distributed to the landless laborers after they were taken from the zamindars. Lakhs of tenants who were tilling the land have become the owner on account of the Tenancy Protection Acts. The situation of the labor, their living has been upgraded. No doubt that this is only a beginning. The 75 years in a life of a constitution cannot be said to be a long area, though for a human being it will be all, in many cases it will be more than the complete life. But for a constitution, 75 years is a not that big span. And therefore, in the last 75 years, in my view, all the three wings of the democracy, the executive, the legislature, and the judiciary have acted in furtherance of the promise of social and economic justice as enshrined in the Constitution. When Dr. Ambedkar insisted on inserting Part 4 in the Constitution, he was criticized that it is nothing else but a post-dated check on a bankrupt bank. Replying the criticism, Dr. Ambedkar said that I am willing to accept the criticism that it is a post-dated check. He said, but I am not willing to accept a criticism that it is on a bankrupt bank. He said that I am sure that one day the bank of my nation will be so able that this post-dated check will be encashed. And therefore we see that his vision of social and economic justice as enshrined in the Constitution has been always in a right track. I just now referred to the achievement of the woman. We have had the President of India from the scheduled caste community. We have now a President of India who is woman and also from the scheduled tribe community. We have had a Speaker of the Lok Sabha from the scheduled tribe community. We had a Chief Justice of India from the scheduled tribe, scheduled caste community, and so on. We find that in various important places like the IAS, IPS, and IFS, the persons from various stratas of society, may be scheduled caste, scheduled tribe, backward classes, are occupying important posts. They are occupying the posts of the Chief Secretaries, the Director Generals of Police. The women who are the most downtrodden are leading the country in many ways. We have ladies who have been Chief Secretaries in various states. We have a lady in Maharashtra who is the Director General of Police. And therefore this journey has always, in my view, has been in a right direction. The court, through its judicial activism, we are always criticized that we encroach upon the field of legislation and the executive. But wherever the executive or the legislative fails to fill in the gap, the courts are required to step in. The We don't derive pleasure in encroaching, but they are only in order to fill in the gap. Like Vishaka was found necessary to, because there was no enactment to deal with the sexual harassment of the woman. Subsequently, that has been enacted. In Moini Jain and Unni Krishnan, the Supreme Court was required to hold that the right to education is also a fundamental right. The Article 21A came to be inserted subsequently. And as held by at least 3 learned judges in Keshavanand Bharati, the courts are also the state within the meaning of Article 12 of the Constitution of India. And therefore, while discharging their duties, the courts are also bound to follow the mandate in Part 4, that is, the directive principles. Justice Beg, Justice Matthews have, in unequal words, held that when the courts discharge their duties, they are bound to follow the directive principles. And therefore, if the court steps in, the act of the court is only in furtherance of the constitutional mandate. On this occasion, I once again congratulate you on your Platinum Jubilee celebrations. On this occasion, let us take a hope that the journey towards the social and economic justice, which has begun in a good way, all of us will make our every attempt, every effort to see that this journey goes further and further, and the dream of the constitution makers is achieved in the real sense. Thank you very much.
Thank you, Lord. Thank you, Lordship, for your blessing and sharing your knowledge about evolution of constitutional law and journey so far at the prism of socio-economic justice and celebrating on concept of distributive justice. Your words will resonate with each one of us till the times to come. May I now request Honorable Mr. Justice Manindra Mohan Srivastava, the Chief Justice, Rajasthan High Court, and Patron and Chief, Rajasthan State Judicial Academy, to please present the memento to Honorable Mr. Justice B.R. Gavai, Judge, Supreme Court of India. Thank you, Lord. May I request Honorable Mr. Justice Pankaj Bhandari, Judge, Rajasthan High Court and Executive Chairman, Rajasthan State Legal Service Authority, to please present the memento to Honorable Mr. Justice Sandeep Mehta, Judge, Supreme Court of India. Thank you, Lordship. May I request Honorable Dr. Justice Pushpendra Singh Bhati, Judge, Rajasthan High Court and Chairman, RSJ, to please present the memento to Honorable R. Venkataramani, Attorney General of India. Thank you, Lordship. An astute scholar, our source of inspiration, our Chairman, Honorable Dr. Justice Pushpendra Singh Bhati, Judge, Rajasthan High Court. Now, may I humbly request His Lordship for vote of thanks.
मैं यहाँ बैठा बैठा ऐसा सोच रहा था कि मुझे जो जिम्मेवारी सौंपी गई है वो धन्यवाद की है, तो मैंने बैठे बैठे उसका संधि विच्छेद किया, तो मैंने पाया कि मेरे पास एक तो धन्य होने की आवश्यकता और एक वाद की। तो वाद तो हमारी ज़िंदगी का एक हिस्सा है, जितने भी लोग यहाँ बैठे हैं, मैंने उस वाद को तैयार करने की कोशिश करी, पर मुझे लगता है कि धन्य तो मैं हुआ क्योंकि मेरे सितारे आज अच्छे थे। जो विधि के क्षेत्र में जो हिमालय हैं, जो एनसाइक्लोपीडिया हैं, जो अपने आप में लीजेंडरी बुक्स हैं, चलती फिरती किताबें हैं, उनको सुनने का ये सुअवसर आज मुझे मेरे साथियों के साथ प्राप्त हुआ। इसलिए धन्य तो मैं हो गया, पर वाद को मैं समेट ना पाया, क्योंकि जब राजस्थान उच्च न्यायालय के कप्तान माननीय मुख्य न्यायाधिपति शास्त्री साहब ने कहा कि कॉन्स्टिट्यूशन खुद अपने आप में एक जर्नी है, वी आर इन अ व्हीकल ऑफ प्रोग्रेस, सेम इज द जर्नी ऑफ दिस ग्रेट हाई कोर्ट, सेम इज द जर्नी ऑफ दिस ग्रेट टेम्पल। उसके बाद जब भारत के गणराज्य के सॉलिसिटर जनरल वेंकटरमणी साहब ने जब कहा कि संविधान के पथ एक रेल की पटरी की तरह हैं, जिनके अंदर एक सामंजस्य और एक विधि का स्वरूप समाना आवश्यक है, तो मैं विस्मृत रह गया उनकी बातें सुनते और समझते। उन्होंने जिस बारीकी से हम सबको ये बताया कि प्रीसिडेंट्स, कॉन्स्टिट्यूशनल प्रीसिडेंट्स के जरिए वी हैव ट्रैवल्ड अ जर्नी, समटाइम्स maybe in the eyes of the jurists we would have deviated, but by and large with the course corrections we have stayed on the track. जस्टिस संदीप मेहता साहब तो इस गुरुकुल और इस विद्या के मंदिर के प्रणेता हैं, और उन्होंने भी जब संविधान की यात्रा के जरिए 3 principles of equality, economic principles, social principles and political principles पे जब अपनी वार्ता रखी, तो कई सारी नई बारीकियां हमेशा की तरह वो खोलते चले गए, और कई सारी बातें हमें जानने को मिली कि भारत के संविधान के अंदर, जिसको हम जितनी बार पढ़ें, जितनी बार समझने का प्रयास करें, इस विस्मृत कर देने वाले ग्रंथ को नमन करने का मन करता है, क्योंकि इस ग्रंथ के अंदर वो एनर्जी है कि आज इतने बड़े बड़े विधिवेत्ता यहाँ हमारे सामने पधारे और उन्होंने हमें उद्बोधित किया। हम सब इंतजार कर रहे थे भारत की शीर्ष अदालत के शीर्ष न्यायाधिपति गवाई साहब के बात का, और वो बात जैसे एक मजबूत एनसाइक्लोपीडिया में होती है, संविधान के हर पक्ष, संविधान की इंक्लूसिवनेस, संविधान के अंदर किस प्रकार से इस यात्रा में आप सबने देखा और आप सबने पाया कि ये सब छोटी चीजें नहीं थी। जहाँ नेशनलाइजेशन हुआ, बैंक्स का हुआ, ट्रांसपोर्टेशन का हुआ, लैंड प्रॉपर्टी वहाँ से फंडामेंटल राइट से निकल करके बाहर गई, 300A में चली गई, पहले वहीं अमेंडमेंट्स हुए। ये सारी यात्रा आज हमें प्रासंगिक लगती है, इसलिए प्रासंगिक लगती है कि अगर ये संविधान की यात्रा इतनी सुंदर नहीं होती तो लाखों लोग अपनी जान गंवा बैठते, और एक आजाद देश को राह प्रदान करना लगभग असंभव सा हो जाता। B.R.Ambedkar साहब और अन्य, डॉक्टर राधाकृष्णन और जवाहरलाल नेहरू और जितने भी वो महान लोग थे जिन्होंने हमें हमारा संविधान दिया, ऐसे समय में हम उनको कई बार नमन करना चाहते हैं कि उन्होंने इतना अद्भुत संविधान दिया जिसकी व्याख्या बार बार मेरे को जस्टिस मैथ्यूज का शब्द याद आ रहा था जब जस्टिस गवाई साहब जो हैं वे व्याख्या कर रहे थे उस पर्टिकुलर एस्पेक्ट की, कि एम्प्टी टम्बलर के अंदर हमें हमेशा ध्यान रखना है कि कौन सा रंग हमें उस टम्बलर के अंदर भरना है। यहाँ बहुत सारे ऐसे मेरे जज साथी हैं और वकील साथी हैं जो यंग हैं, जो जिनके पास आज वो एम्प्टी टम्बलर मौजूद है, और मुझे पूर्ण विश्वास है कि वो उसके अंदर एक अच्छा रंग, सुंदर संवैधानिक रंग भरेंगे जिससे देश मजबूती से आगे बढ़ सके। जब चीफ साहब ने कहा कि प्लैटिनम जुबली सेलिब्रेशन का एक बड़ा कार्यक्रम राजस्थान जुडिशियल एकेडमी को सौंपा जा रहा है, तो गर्व से एकेडमी और एकेडमी के साथियों और एकेडमी को चलाने वाले हम समस्त जो मेरे साथी हैं उन सबका सीना गर्व से फूल गया। रातों रात बैठ करके सारी बात की रूपरेखा पंकज भंडारी साहब, दिनेश मेहता साहब, विनीत माथुर साहब, मनोज गर्ग साहब, वीरेंद्र कुमार साहब, मोंगा साहब और मैंने सबने मिलकर के रातों रात इसकी मिनट टू मिनट रूपरेखा तैयार करनी शुरू करी और लगभग 10-15 दिन से हमने अथक प्रयास किए कि एक सुंदर प्लैटिनम जुबली सेलिब्रेशन के रूप में आज का दिन हर मोमेंट के रूप में हम सब मिलकर के एंजॉय कर सकें। और इस सुंदर आज जिस रंग में ये सारा कार्यक्रम उभर के सामने आया है, मैं दावे के साथ कह सकता हूं कि चीफ जस्टिस सफल हुए अपनी उस बात के अंदर कि जो ये चाहते थे, आप शायद चाहते थे कि प्लैटिनम जुबली सेलिब्रेशन की जो हाइट होनी चाहिए, उसका जो वेट होना चाहिए, उतना हिमालयन प्लैटिनम जुबली सेलिब्रेशन इस सुंदर हाई कोर्ट का, इस महान हाई कोर्ट का, इस महान एकेडमी का आज हमें करने का मौका मिला। जब 4 बजे कल न्यायालय का समय समाप्त हुआ होगा तो जयपुर से मेरे सारे भाई बहन वहां से दौड़े होंगे इस प्रोग्राम को अटेंड करने के लिए, और देर रात तक उन्होंने यहां पहुंच करके और अपनी उपस्थिति यहां पधारे। यहां के भ्रातागण सब दिन रात लगे हुए थे इस कार्यक्रम के लिए। मैं किसको धन्यवाद दूं और किसको न दूं ये मेरे समझ में नहीं आता, लेकिन धन्य तो मैं हूं और धन्यवाद भी है। मैं उन वकीलों का विशेष रूप से, उन मजबूत वकील समुदाय का भी धन्यवाद देना चाहता हूं जिनकी उपस्थिति के बिना आज ये प्रोग्राम पूर्णतः अधूरा रह जाता। यहां समस्त राज्य के प्रथम अधिवक्ता एडवोकेट जनरल साहब पधारे हैं और उन्हीं के साथ उनके बाजू में पूर्व महाधिवक्ता बैठे हैं और पूरी एडिशनल एडवोकेट जनरल्स की टीम बैठी हुई है, यूनियन गवर्नमेंट्स के एडवोकेट्स की टीम बैठी हुई है, बार काउंसिल के चेयरमैन बैठे हुए हैं, बार काउंसिल के वाइस चेयरमैन बैठे हुए हैं, जयपुर राजस्थान हाई कोर्ट की बार के पूरी लीडरशिप आज हमारे सामने यहाँ है, वरिष्ठ लीडरशिप यहाँ पे है प्रेसिडेंट समेत। जोधपुर राजस्थान हाई कोर्ट की वरिष्ठ लीडरशिप आज हमारे सामने, हमारे अध्यक्ष यहाँ विराजे हुए हैं, उनके साथ उनकी कार्यकारिणी के सदस्य हैं। सभी ने मिलकर के एक, आज ये सबको मालूम था कि ये हॉल छोटा है, इसलिए पहले से इस बात का इत्तेफाक रखा जा रहा था कि हर चीफ साहब की ये इच्छा थी कि हर तबके से, विधि से जुड़े हुए हर तबके से व्यक्ति आए, और इसीलिए नेशनल लॉ यूनिवर्सिटी के वाइस चांसलर साहब भी आज यहाँ आमंत्रित हुए और उन्होंने भी समस्त समय अपने साथियों के साथ दे करके और आज हमारे इस प्रोग्राम को सक्सेस बनाने के अंदर एक बहुत अच्छी भूमिका निभाई। जय नारायण व्यास यूनिवर्सिटी, जिसके प्रोडक्ट शायद राजस्थान की दूसरी बड़ी स्टेट यूनिवर्सिटी है, उसके डीन फैकल्टी ऑफ लॉ सुप्पा जी भी यहाँ मौजूद हैं और उन्होंने भी यहाँ पूरी तरह से इसमें भागीदारी निभा करके कार्यक्रम के अंदर हमें धन्य किया। मैं विशेष धन्यवाद देता हूँ मैडम वेंकटरमणी का, जिनको जब हमने ये कहा कि ये इसमें आप पधार के क्या करेंगे, आप जोधपुर घूम लीजिए, कुछ ऐतिहासिक चीज़ें देख लीजिए, तो उन्होंने कहा कि नहीं, ये मैंने स्पीच साथ में मैं सुनती रहती हूँ और मैं करेक्ट करती रहती हूँ सर को, और मैं चुपचाप धीरे से सुन रहा था। मैं चुपचाप धीरे धीरे सुन रहा था। मैडम ने पूरी सहभागिता जताई कि मैं वो जहाँ स्पीच देंगे मैं वहाँ अवश्य रहूँगी, और चाहे कितना भी लंबा कार्यक्रम हो मैं वहाँ बैठूंगी और समस्त कार्यक्रम में पार्टिसिपेट करूँगी। मैं उनका भी विशेष धन्यवाद देना चाहता हूँ। और यहाँ इस हाईकोर्ट की बैकबोन, हाईकोर्ट की रजिस्ट्री, इस एकेडमी की बैकबोन, इस एकेडमी की टीम और सभी मौजूद हैं, इन सब का मैं अत्यंत धन्यवाद देता हूं तहे दिल से। और मैं उन जजेस के जिनके कंधे पे कल राजस्थान हाईकोर्ट की राजस्थान की समस्त अदालतें चलेगी, जिसमें हाईकोर्ट से लगा करके और सिविल जज तक शामिल हैं, समस्त अदालतें जिनके कंधे पे चलेगी, जिनके ऊपर आज इस प्लैटिनम जर्नी की, प्लैटिनम जुबली, मुझे पूर्ण विश्वास है कि यहाँ बैठे हुए वो सब जो सितारे हैं, जब हम सेंटिनरी सेलिब्रेशन करेंगे 100 साल में, तब उनके कंधे पे ये ऐसा प्रोग्राम होगा और सुपर सक्सेसफुल होगा। मैं चूंकि धन्यवाद में ज़्यादा बोलना उचित नहीं है और मैं पहले ही अपनी सीमा को उल्लंघ चुका हूँ, लेकिन मैं एक आखिरी बात कह के अपनी बात को विराम देना चाहूँगा। मेरे से जरा बियर करिएगा, एक बस छोटा सा ही समय लूंगा मैं, बोलना नहीं आएगा तो कुछ गलती होगी तो भी कोई बात नहीं। निर्वनो वद्यते व्याघ्रो निर्व्याग्यम दिदत्ते वनम तस्माद्य याग्रो वनम रक्षे द्वयम व्याघ्रम च पाल्यते। क्या आप में से कोई बता सकता है कि संस्कृत का श्लोक कहां से आया? चलिए मैं बता दूं। अभी तो ये गवाई साहब के संदीप मेहता साहब के और प्रशांत मिश्रा साहब के जजमेंट में से आया है, क्योंकि आपने अपने जजमेंट में ये महाभारत का श्लोक दिया। जब आप फॉरेस्ट से संबंधित इंपॉर्टेंट पेयल सुन रहे थे, तो आपकी जजमेंट की ओपनिंग लाइंस हैं, जिनको मैं अंग्रेजी में भी आपके लिए पढ़ देता हूं। द टाइगर पेरिशेस विदाउट द फॉरेस्ट एंड द फॉरेस्ट पेरिशेस विदाउट इट्स टाइगर्स। Therefore, the tiger should stand guard over the forest, and the forest should protect all its tigers. Wonderful words. I request everyone in this August gathering to read this beautiful judgment, which is a part of T. Godavarman judgments. And before I part by saying Jai Hind, I say that let's all give a loud applause to the forest bench of India, which is taking care of the silent forest, and maybe a standing ovation, because may God give them. Thank you so much. May God give them, may God, this special bench, forest bench, be given enough strength to protect every human being, living being, forest, preserver, water resources, every hills and every natural resources there is there. Thank you so much. Jai Hind, Jai Bharat.
May I request one and all to please be seated? धन्यवाद माननीय न्यायाधिपति श्रीमान डॉक्टर जस्टिस पुष्पेंद्र सिंह भाटी, जज राजस्थान हाई कोर्ट एवं चेयरमैन राजस्थान राज्य न्यायिक अकादमी. Before we end, may I request you all once again to please rise for national anthem.
जन गण मन अधिनायक जय हे भारत भाग्य विधाता, पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल बंगा, विंध्य हिमाचल यमुना गंगा उज्जल जलधि तरंगा, तव शुभ नामे जागे, तव शुभ आशीष मांगे, गाहे तव जय गाथा, जन गण मंगल दायक जय हे भारत भाग्य विधाता, जय हे जय हे जय हे जय 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 हे.
With this, we come to the end of the seminar. I request all the distinguished dignitaries, participants, special invitees, I'll request all to please join us for high tea in the library hall.
This way, sir. This way, sir.
I had given an idea what is coming. कोर्ट में रोज बेनिफिट होता है ना.
Robust encyclopedia, sir.
हम उनसे ये बात कर रहे थे कि आप बस उसमें से एक जजमेंट का पार्टी का नाम देख लेते बस, एंड देन
वो भी नहीं जरूरत होती है, वो भी जरूरत नहीं पड़ती.